Appointed to the faculty of Rutgers upon his graduation with high honors in 1966. Now, Professor Askin was admitted to the law school without an undergraduate degree, and he was awarded a BA from City College of New York at the same time he received his JD here at Rutgers. In 1970, Professor Askin established the Constitutional Litigation Clinic as a part of the law school's curriculum. He is still associated with the clinic. Now I will announce the issue, procedure, and facts of the case. Now, in the U.S. District Court for the Northern District of Illinois, plaintiffs, who were petitioners, residents, and organizations, filed 3 suits against respondent municipalities, alleging that municipal ordinances banning handgun possession violated the 2nd and 14th Amendments of the United States Constitution. The District Court upheld the ordinances, and the United States Court of Appeals for the 7th Circuit affirmed. The Supreme Court then granted cert. In a 5-4 decision, the United States Supreme Court reversed the 7th Circuit's decision. The court held that the Second Amendment protected the right to keep and bear arms for the purpose of self-defense, and that the Second Amendment was fully applicable to the states by the Due Process Clause of the 14th Amendment. We will now begin our debate. First up, Professor Askin will speak for 20 minutes. Following him will be Neily for 20 minutes. At the end of this period, each participant will have a 7-minute rebuttal, and finally, we will have a 30-minute question and answer period. Thank you very much.
Good afternoon. I'm not a historian, but I claim to be a Second Amendment scholar. But I have read the Heller and McDonald opinions and drawn some tentative conclusions. But let me start by reading the language of the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, while I'm not a historian, I do know a little bit about English grammar. And clearly, the right to bear arms is a subordinate clause, subordinate to the state's right to maintain a militia. And clearly, the right to bear arms is somehow connected with the state's authority to maintain a militia. Now, the framers surely knew how to spell out affirmative rights when they wanted to. Congress shall make no laws, the First Amendment. No soldier shall be quartered, the Third Amendment. The right of the people to be secure in their persons, the Fourth Amendment. No mealy-mouthed, backdoor language to protect those affirmative rights. And I think this was stated most persuasively by Justice Stevens in his dissent in the McDonald case. The Second Amendment differs in kind from the amendments that surround it, with the consequence that its inclusion in the Bill of Rights is not merely unhelpful, but positively harmful to petitioners' claim. Generally, the inclusion of a liberty interest in the Bill of Rights points towards the conclusion that it is of fundamental significance and ought to be enforceable against the states. But the Second Amendment plays a peculiar role within the bill, as announced by its peculiar opening clause. Even accepting the Heller Court's view that the amendment protects an individual right to keep and bear arms, disconnected from militia service, it remains undeniable that the purpose for which the right was codified was to prevent elimination of the militia. It was the states, not private persons, on whose immediate behalf the Second Amendment was adopted. Notwithstanding the Heller Court's effort to write the Second Amendment's preamble out of the Constitution, the amendment still serves a structural function of protecting the states from encroachment by an overreaching federal government. Like Justice Stevens, I had long assumed the individual right to have a gun was related to the ability of the state to have a militia, at least until Justice Scalia disabused me of that notion. But I found Justice Scalia's reasoning not only fanciful, but downright scary. For years, conservative jurisprudence, when it came to examining individual rights that came into possible conflict with national security, always relied on the same mantra: the Constitution is not a suicide pact. How many times had conservative jurisprudence repeated that phrase to explain why they were voting down individual rights? But in Heller, the precursor to McDonald, Justice Scalia said it is precisely that the purpose of the Second Amendment was to protect the right of violent revolution against the federal government. For example, Scalia explained the amendment was adopted because of, quote, a fear that the federal government would disarm the people in order to impose rule through a standing army or select militia, unquote. And he added that it, quote, was understood across the political spectrum that the right to bear arms helped to secure the ideal of a citizen militia which might be necessary to oppose an oppressive military force if the constitutional order broke down, unquote. In other words, in Scalia's view, the founders specifically provided in the nation's charter a mechanism for popular uprising. Wonder where Sharon Angle got her idea for Second Amendment remedies against Congress. You know, back in the McCarthy era, most of you are much too young to know much about that, there were prosecutions in this country under the Smith Act, series of prosecutions all across the country of leaders of the Communist Party. For what? For teaching and advocating the overthrow of the government by force and violence. That was the charge, conspiracy to teach and advocate. They were never even accused of stocking weapons. They were accused of teaching and advocating overthrow of the government. Well, I think the defendants probably had the wrong lawyers to defend them. Their lawyers defended them under the First Amendment. They said they were speaking. They had a right to advocate. It was free speech. They should have had Scalia or a Scalia-type lawyer to raise the Second Amendment defense. They were accused of advocating what Jefferson and the other founders advocated, the right to overthrow the government. Even more puzzling from the perspective of conservative jurisprudence is McDonald. I always thought conservatives were protectors of state and local government from the big bad feds. States' rights. That's been the call of conservatives for how many years in this country? Hard to think of a more intrusive attack on state and local sovereignty against encroachment by the feds than the decree by the conservative 5 justices on the Supreme Court that the city of Chicago or the state of Illinois was powerless to bar gun ownership, to protect their citizenry from the harm that can be caused by guns. McDonald's result is particularly stunning, since it was an interpretation of a provision that's on its face does nothing more than authorize states to maintain their own militias. Yet the conservative majority took the occasion to overrule its long-standing precedent, some 130 years I believe it stood, to strip local government of the power to control gun ownership. Conservatives who are so concerned about respecting state autonomy took it upon themselves to prohibit the states and localities from controlling the possession of firearms by their own citizens. As Justice Stevens said in his dissent in McDonald, quote, "The Second Amendment is a federalism provision. It is directed to preserving the autonomy of the sovereign states, and its logic, therefore, resists incorporation by a federal court against the states." And by calling the right to bear arms a fundamental right, protected by the Due Process Clause of the 14th Amendment, the majority left completely unresolved what type of gun regulations a state might even enact. I note the Tea Partiers now seem now to claim the right to carry weapons to political rallies. Is that a right protected by the Second Amendment? Justice Breyer, his dissent in McDonald, pointed to the many difficult questions left unanswered by the court's Second Amendment decision. I quote Justice Breyer, "Consider, too, that countless gun regulations of many shapes and sizes are in place in every state and in many local communities. Does the right to possess weapons for self-defense extend outside the home, to the car, to work? What sort of guns are necessary for self-defense? Handguns, rifles, semi-automatic weapons? When is a gun semi-automatic? What are different kinds of weapons likely needed? Does the time of day matter? Does the presence of a child in the house matter? Does the presence of
Whenever you're ready.
Yeah.
Got it. Just read the top two parts, yeah?
Yeah, from up here.
Mm-hmm. At podium? Or?
Yeah.
We're starting off like that.
Yeah. Okay, we're starting now. Yeah.